Hey y'all, Rob here with ATX Legal, and today we're going to talk about parole revocation. This is the third part of a three-part series on parole, so if you have other questions on parole, you might want to check out my last two videos. Today we're just going to be talking about the revocation process, which is what happens when you commit a violation on parole and they decide that they're going to revoke your parole, which means you could be back in custody. And unfortunately, if you're back in custody, you could be asked to serve the remainder of your sentence in some cases. But not all cases. They do have to give you due process with a hearing, and after the hearing they might not revoke you at all, but there's a lot of factors that go into it. But first, let's back up and we're going to talk about a blue warrant. A blue warrant is going to work a lot like a regular warrant. Basically, if a warrant is issued, the police have that in their database, and if they find you, they're going to come arrest you, or they might go and make a special trip to come arrest you to put you back in custody. There's some big differences with a blue warrant. The biggest difference is you can't post bond. So if you get picked up on a blue warrant, you're awaiting a parole revocation, you are not going to be able to bond out. Sometimes the parole officer will make the decision to not issue a blue warrant. In that case, you could wait for the revocation hearing and be free in the meantime. That's totally up to the discretion of the parole officer. So if that blue warrant is issued, there's nothing an attorney is going to be able to do to get you bonded out of custody. You just have to wait for that hearing. Now that hearing is going to be typically within 41 days, unless you waive that hearing, or if you need to get some more evidence together for the hearing, you can set that off. But parole has to get that hearing in within 41 days, but you could spend all 41 of those days in custody, and there's really nothing an attorney can do to get you out. Now, there are two types of violations that can get a revocation started. The first is what's called a technical violation, and the second is by committing a new crime. A technical violation, it just means there are some rules that are set up for parole. When you start in the parole process, you have to check in every so often. You have to avoid alcohol. Maybe you have to avoid specific people. There's a lot of different rules that can be put in place. If you break those rules, but they don't rise to the level of a new crime, this is called a technical violation, and it can result in a revocation. And of course, the second one, under all parole rules, you cannot commit a new crime. So committing a new misdemeanor or a new felony can get that revocation process started. Now, revocations for new crimes are far more common than technical violations. Why? Well, first, it's an easy demarcation. You have committed a new crime, or you've been charged with a new crime. It's very easy for parole to just do that paperwork and get that process started. And the second reason is these technical violations, usually they'll give you a few chances, unless you just completely don't report to the parole officer. That's kind of the big technical violation that's going to get you revoked right away. But if you fail a drug test, if you miss curfews, things like that, you'll usually get 2 or 3 or 4 chances before they revoke you on purely technical violations. But if you are charged with a new crime and you're on parole, it complicates things immensely, both for the parole and for the new charge. So consider this situation. It's actually very common. So if you get arrested, imagine you get bonded out, and that could be with a PR bond that's free, or you go pay a bondsman a percentage of the bond amount, or you pay a cash bond. However you do it, you bond out. Well, a few weeks later, parole gets this information, and then they file a blue warrant. So now you've bonded out and you've gone through that process, but there's still a warrant. When you get picked up again, now you've been arrested twice for the same charge, and you forfeit that bond. So if you've paid a bondsman, that money is gone. You can never get that back. So having that parole issue when you've been charged with a new crime adds layers and layers of complexity for you and for your attorney. But keep in mind, the parole officer does have discretion to not issue a blue warrant when you're being revoked, even for a new charged crime. So there are cases where you will be charged with that new crime. There might be a revocation pending, but that blue warrant won't issue. That's completely up to the discretion of your parole officer. So I just want to point out, karma is real. I would treat your parole officer very much like your favorite aunt or uncle. Talk to them, have chats with them, just be friendly, because they do actually have a lot of discretion, especially in this case when there is a potential revocation or a potential blue warrant. They have complete discretion to issue that or not. And there's nothing your attorney can do about that once they've decided to issue that blue warrant. Now let's talk about the actual hearing process. A new rule, and it's not really a new rule, it's just a new way the courts have interpreted the rule, is that the revocation hearing must happen within 41 days if you're in custody. So if you've been picked up and you're waiting for your revocation hearing and you're in custody, the parole process all the way to the final decision has to happen within 41 days. Now you can waive that if you'd like. If you need to get more evidence together for your case, you can push that off, but on the parole side, they have to have it done within 41 days. Now the parole hearing will typically happen in custody. So there's a room, like for example, in Travis County, the Del Valley Jail, there's a room that's cordoned off for parole hearings. Usually the parole officer kind of runs the show, and then there's a hearing officer who's separate from the parole officer who will make the decision along with a panel of 2 others. Now at the hearing, the parole officer and the parolee can call witnesses. Usually the parole officer is going to call police officers or the alleged victim in the new crime or anybody else who they need to prove up their case. Usually this happens remotely by Zoom, so the officer can just take their phone or their computer and appear via Zoom. So that means there's a lot fewer times where you have a case where the officer just doesn't show up. Now an important point here is parolees are not entitled to a lawyer, even though you're having a hearing here that could determine whether you go to jail for a very long time, you go to prison for years on your sentence, or you could be released right then and there. You're not entitled to an attorney, and you will not get a court-appointed attorney. So I'll talk more about that later, but it's something to think about if you do have that revocation coming up, whether to hire an attorney. And again, you have to make that decision quickly because that hearing is coming up within 41 days. You actually have 2 hearings in that 41-day process because there's going to be a preliminary hearing and a final hearing. A lot of times at the final hearing, they just sort of incorporate everything they got from the first hearing, and so it's kind of a nothing. But procedurally, they do have to have both of those hearings within the 41-day time period. The hearing officer will take the evidence from the preliminary hearing and the final hearing, take that to a panel of 3 decision makers, and they will make the decision of what happens. Now, usually they're going to follow whatever the recommendations are of the hearing officer. He's the one that was actually there. Rarely they will go against what that hearing officer says, but you can usually get a pretty good indication of how the hearing is going to go just by talking to the hearing officer. And they actually have to make 2 decisions. The first is whether a violation actually occurred, and they have to decide by the preponderance of the evidence that a violation occurred. Once it has been determined that a violation has occurred, then they have to determine what kind of punishment will be the result. Now the punishment can be all the way up to completing the rest of the sentence. So for example, if you have 5 years left on your sentence, the hearing officer could determine that you have to spend the rest of those 5 years in custody, or you could come back up for parole hearings later subsequently to that. But it literally could be the full 5 years. That could be what is riding on that hearing officer's decision. But they have lesser punishments that they could do as well. They could continue you on parole, or they could continue you on parole but add additional conditions. Maybe they want you to do inpatient treatment somewhere, or maybe classes regarding anger management. They have a lot of tools at their disposal that they can add to your parole and add a punishment even if you're not in custody after the revocation hearing. And a third possibility is that they could order you to go to an in-custody treatment or some kind of in-custody program that could last 6 months or a year before you are released back on parole. So even though that's not technically a full revocation where you're going to be spending the rest of your sentence in custody, it still means that you're going to be in custody for another year. So nobody wants that, but that is a possibility from a revocation hearing. Now, obviously, the result of that hearing is going to vary widely case by case. For example, if you're in for a DWI, an alcohol program might be required, but if alcohol had nothing to do with your case, obviously they're not going to put you into an alcohol treatment program. So it just varies widely case by case. I'm not going to go into each specific case and how that goes, but that's kind of why it would be a good idea to talk to an attorney before you have that revocation hearing, just because there is a wide variety of outcomes. And now I'm going to talk about street time, and this is a very common question. The framing of it is this: if you were out on parole for a certain time, let's say a year, do you get credit for that time on to your sentence? So another way of putting it is your sentence reduced by the amount of time you've been free on parole? And the answer is sometimes yes and sometimes no. So the rule is, if you've been released more than half of the time that you were going to spend on parole, then you do get credit for that street time. But if it was less than half the amount of time that you were going to be spent free on parole, then you do not get credit. It is a 0 or 1, all or nothing proposition, and you can do the math in your particular case and you can find out for yourself yes or no. There is no gray area here. So let's go into some examples. So let's say you have someone who is given a 10-year sentence and released at 5 years. That means they're scheduled to be on parole for 5 years before their sentence is complete. If that person then picks up a DWI and gets revoked after 2 years, that's less than half the time that they were going to be released. Remember, they were going to be released for 5 years. So if they get a DWI after 2 years, they do not get credit for any of their street time. It goes away and they still have 5 years left to serve on their sentence. Whether that seems fair or not to you, that's just the way it works, unfortunately. But if that same person who had 5 years to serve picked up a DWI after they had been on parole successfully for 3 years, they would get credit for all of their street time. So they would get the full 3 years and they would only have 2 years left on their sentence. And when you're measuring that time, the time starts from the day they are released and ends on the day the revocation was issued. And unfortunately, once you lose that street time, it's gone forever. You can't get it back. I'm going to end with one final point, and that's a question I get sometimes, which is, do I need an attorney for a parole revocation hearing? Now, you don't get a court-appointed attorney for this. And some people think, well, I don't get a court-appointed attorney, it must not be important. I disagree with that completely, because you could potentially, as we discussed previously, you could potentially be in custody for the rest of your sentence based on the outcome of this hearing. The reason you don't get a court-appointed attorney is really a technical legal reason, and that is that courts have found that there's not a constitutional liberty interest in parole. And that's a fancy way of saying we're letting you out because we want to let you out. We don't have to let you out. It's not a constitutionally protected interest the way you're constitutionally protected when you are charged with a crime. So courts have just decided, for whatever reason, that they don't extend that constitutional protection to parole. Now, I would argue that that's really the wrong decision, but that's what courts have decided. So because you're not given an attorney in parole, this leads to a lot of people representing themselves at the hearing. And for some people, I'm sure they can do that okay. For the vast majority of people, A, they're not trained as a lawyer, so they're not going to necessarily be good at advocating for themselves. And B, they're going to be required to make statements in court. And you're giving up that right to remain silent, which you do have at a parole hearing. If you represent yourself, you're giving up that right. So for those two reasons, I would say it is a very good idea to have an attorney. Just because the court has said you don't get a court-appointed attorney for this particular hearing doesn't mean it's not important. It is important, and it can be the difference in your case. And it actually can be a good idea to make a short and concise statement, but it's much better to go over that statement with your attorney ahead of time so that you limit it just to the important factors and you don't go outside of that and potentially harm yourself in the process. And again, this was part of a 3-part series, so if there were any questions about parole that didn't get answered, you can check out the last 2 videos or go to my blog. None of this is legal advice, but if you do want legal advice on your particular case, if you have a revocation hearing or just a parole hearing coming up, you can visit us at atx.legal for a no-cost consultation.